Well, hi everybody, and welcome to ZTV Live. Today is Wednesday, February 17th, 2021. Thank you so much for joining us. I'm so happy to welcome our guest tonight on his show, Legal Matters, and that is our guest host, I should say, Paul Dean. Paul, welcome back to ZTV.
Thanks, Susan. It's great to be back,
It's great to
as
have you
always.
here. Yep, as always is right. You're a long time friend of ZTV, and you've been with us really from the very beginning. So, not a lot of people have that claim to fame, but you do.
Well, I understand that you received some recent recognition or award, ZTV, and some of your
Mary
leadership
Wadland,
there.
yes, our publisher. Thank you for
Yeah,
mentioning it. She got, I believe, the best small business with Alignable,
right.
for 2021. So well deserved on Mary's part. She's a hardworking woman. She has really built a little media enterprise with the Zebra
Mhm.
between our monthly newspaper, our website. We have a huge presence in social media, and I mean, selling all good news all the time is
People
quite an
need these
accomplishment.
days.
Yeah,
So, well,
exactly.
congratulations to Mary Ann Zebra. That's a great
Thank you.
award.
Thank you. Yeah,
I,
she definitely
well deserved.
deserves it. We were happy to see it, and congratulations to you. You passed a milestone last month, I believe, or maybe with in 2021. You want to tell us about that a little bit?
Well, yeah, thanks, Susan. I just had my second anniversary from launching the law practice. So I've lasted this long and have managed to grow and sort of establish the practice in challenging times, which
Yes,
has been interesting to say the least. And a lot of the model as far as services and business delivery has changed drastically in the last year, as many people are aware.
uh huh.
But yeah, I just put out a newsletter. I went back. I've had 81 clients that I've worked with.
That's
Um,
great.
76 wills and handled some all kinds of different matters. About a dozen trusts, and I've got six or seven estates that I'm helping to administer at this point in time. So, and I've got
That's
about a dozen small businesses that I've worked with in the community now. So
that's
it's
really great.
fantastic,
And that's a great
extremely
milestone.
painful.
Yeah, it's a milestone for a small business to pass that. The first 2 years are tough. And so I guess they're all tough, but it's nice to, as long as you keep, like you said, keep growing in that upward trajectory. It can go slowly, you just want it to keep
Yeah,
going, is what you want. So thank you. We just got a
absolutely.
little shout out, a hello, or please everybody who's watching tonight, don't be shy. We're here to. Paul is here to answer your questions, and I'm here to make sure Paul gets your questions. He might be able to see them also. So please don't hesitate to bring any questions, I would say, regarding especially estate administration, but any questions that you have for Paul, I think he'd be happy to answer them. And speaking of, now I interrupted you. Was there anything else that you wanted to talk about with your second anniversary, or
It's just I just want to thank all my clients and all my supporters and really all my friends and referral partners that have helped me along the way. It's been amazing the support I've gotten from the community and the confidence that people have shown. It pays to have a great network of good friends that have helped me along the way. So I just want to thank you. Zebra has been a good partner for me, obviously. So I just want to, I'm very grateful. Like to say, we've doubled the size of our staff in that 2 year
that's
period
right.
from to two. So a shout out to my very capable business manager, Sarah.
That's right. That's right. Sarah is invaluable as your business manager, and it's great to have her helping you with all of your stuff that you're working on. So, um,
Absolutely.
well, let's without further ado, let's get right into our into your what we're all here for tonight, and that is the kind of the top 10 issues and stuff that people can learn about in terms of estate administration. And when does estate administration come into play? What is it?
Sure. So it's always a difficult time when you lose someone that's close to you in your life. Uh, you know, a lot of times when you lose a parent or a spouse or a sibling, you're taking the time to grieve and deal with family and funeral arrangements and all of those types of things. But you know, when you're dealing with this process, the next thing that usually gets thrown onto your plate is you become the person that's responsible for administering the estate.
Mm-hmm.
And so when that sort of is thrown in your lap, administering the estate is basically the process of gathering up the assets of the estate and then distributing them according to the terms of the estate plan to the rightful beneficiaries. On the surface, it seems like a fairly easy type thing. We've all seen TV shows and movies where the family all gathers around and the lawyer, comes and reads the will and says, you get this and you get that. And,
I'm thinking of Knives Out. Yeah.
Right.
It's not always like that.
The estranged, crazy brother in the corner gets left out and then sues and all that kind of stuff. So,
Mm-hmm.
it's rarely is it that dramatic, but a lot of times, a lot of issues do arise, and essentially there are a lot of responsibilities that come up.
And that was I was going to lead right into that. So, who is responsible for administering this estate?
So, if the decedent, the term we use for the person that's recently passed, has had an estate plan in place, if they have a will, if they have a trust, that person is usually named. It's someone that when they prepared their will that they wanted to have this responsibility, and it's pretty straightforward at that point in time because usually it's often a spouse if there's a surviving spouse. If not, there's children usually, or if not, usually a trusted friend or a business associate. Some people prefer to have an attorney or a financial advisor step into that role. So really, it's who's named. The more challenging situation is what happens when there is no will, and really that can be any beneficiary or close family member that basically is the first one to show up and offer the will for probate. So it can get into a situation where perhaps if there are siblings that don't see eye to eye on something, they'll have to battle it out to see who gets the privilege of administering the estate. And if no one steps up to do it, or no one has the capability, if they're not a Virginia resident or they can't qualify, the court will actually step in, and they have a designated sort of list of attorneys that can be court appointed to help administer the estate and carry out all the legal requirements and the fiduciary requirements that are involved with the process.
Right. So really probably want to avoid that and make somebody who knows the people be making the decisions. Somebody who knew
Right,
and
absolutely.
their best interest at
And
heart.
when it comes to estate administration, it's obviously if you've done a good job on the planning side of things. We talked about estate planning and the importance of that the last time we were together, making sure you have your will in order and all of that kind of stuff. When you have that done, the estate administration process goes that much more smoothly.
Yeah.
So that's why we talk about, you can end up saving a lot of money from your estate after you're gone. I mean, maybe you don't care, but the small expense that you have in making sure that your estate planning is in order can save a lot of expense and heartache once you pass away on your family and your beneficiaries.
Right.
those types of things.
So the next are the specific duties of the estate administrator.
Exactly. So most people believe that, again, they have a general notion that once they do find themselves to be the executor or the fiduciary or the trustee of the estate, that, it's just a matter of gathering up the assets and then distributing them to the beneficiaries. And really that is the primary duty. But there are also a ton of steps involved. Um, and, in addition to, that basic responsibility, the executor and the administrator, has to first find the estate planning documents to see if there's a will or anything like that involved, and make sure that hopefully you've got an estate plan that serves as sort of the map, and guides you on sort of what the wishes of the decedent were when they were alive, on how they want their estate to be handled. So there might be specific requests when it comes to funeral and burial arrangements or cremation and those types of things. And then there might be specific, obviously, instructions on sort of who gets the assets and how they're distributed and those types of things. Then, and then you enter the process. It's your responsibility to probate the will. And we'll talk about that, in a second. But that is a process that's supervised by the state circuit court. It is a legal requirement in most cases. There are some cases where probate isn't required, and we can talk about that as well. But offering the will for probate and filing an official inventory of assets, officially qualifying with the county clerk. An estate administrator is also responsible for taxes for the estate. So there's filings that have to be done with the federal government. There's filings that have to be on both behalf of the estate and the decedent. There's filings that have to be done with the state, and also settling debts of the estate. I mean, that's one of the big things as well. Is if the decedent had mortgage, credit card debt, any kind of outstanding loans and things like that, it's the administrator's responsibility to make sure those debts are paid from the proceeds of the estate before they can then
release any funds to the people. Again, pointing, again and again, as with all of these topics that you bring up that are so important, but setting it up ahead of time answers all these questions, and it makes it just so much easier. And you talk about an administrator, and when you hear about a will, you also think like there's an executor, and there's trustees, and there's fiduciaries, and there's kind of all this kind of, I wouldn't call it necessarily, this part isn't legal mumbo jumbo, but there's a lot of words that or descriptions that are they really the same thing?
There are some nuances, but essentially they're all the person that's been assigned the role to administer the estate.
Okay.
So when we say administer the estate, it's either the trustee or the fiduciary or the executor or whoever's in that role. So when you're talking about executor, that's usually associated with a will. So when we write wills, you name the executor of your estate, and that's the person that's in charge of the probate process and things like that. If there's a trust, obviously, the administrator of the estate then is referred to as a trustee, and then the state and the courts that you deal with and anything basically also like to interchange the word fiduciary, because that basically implies that you have certain financial responsibilities to properly administer the estate, but you're also you're entrusted with the estate assets, and that's very important to note, because you have a legal duty and a legal obligation to distribute the assets, gather the assets without mismanagement. You have to account for everything that's there. You have to make sure that you're not siphoning money off of the estate for expenses that aren't allowed. These are the types of issues that that have a lot of problems.
Yeah.
It causes people a lot of problems down the road. And, not to imply that most people are dishonest about it, but people just, don't understand sort of, either the process or really what's allowed and what's not allowed.
Yeah. And it's hard to know that you don't know what you don't know, not to sound like,
Right.
Bill Clinton or anything, but I mean, really, it's hard to know what questions to ask or to, what, if you're doing the right thing. So, um, so somebody who has been given an estate to administer, I mean, they'd be well advised to have an attorney look over the paperwork, right? Because the attorney would be able to be like, oh, hey, you have to do this and you have to do that.
Yeah, and it's a question I get asked all the time. I mean, do I need to hire an attorney? All of a sudden, this duty. Not only do I have to spend the time and the effort to do this, but now I have to hire an attorney, or not necessarily just an attorney. There CPAs that are helpful dealing with tax issues.
Right.
There are trust companies or financial advisors and things like that that can help with the process as well. And so, if there's any complexity at all to the estate, or if you're just completely clueless as to how the process works, I always recommend that you hire some professional help, especially if the estate has any kind of significant assets. That professional help is also an expense of the estate. So it's not really an out-of-pocket expense for the estate administrator. Now, it could eventually end up reducing their amount of inheritance if they are a beneficiary. But oftentimes, it'll save you so much time and headache. And I've been brought into situations sort of halfway through the process and had to unwind the mess, and it ended up, again, folks trying to save a couple of bucks end up spending a couple of $1,000 unwinding issues.
It's unfortunate.
That's not to say, some people are very capable, and I've certainly seen, people who have, done this successfully on their own, or, what I tell to some of my clients is, hey, look, you can do most of this yourself, but, spend a couple of hours with me so I can guide you through the process. And other people are just like, hey, I don't want to deal with this at all. Just tell me where I got to show up, where do I have to sign, what do I have to do, and feel more comfortable with the professionals kind of handling it all.
Yeah, that's a school I go to, that's for sure. Okay, and so you mentioned this before, and I realize I jumped ahead a little bit asking that question. Sorry about that, but you mentioned the word probate before, and I've heard, everybody has heard the word probate. It's a exceedingly legal term. What is probate? I mean, I confess I'm a little fuzzy on it.
Yes, and it is a fuzzy thing, but essentially, probate is the court-supervised process whereby the administrator offers the will for the public record, qualifies as the estate administrator, and then the will becomes officially probated once it's given over to the courts. It becomes subject to review by both beneficiaries, interested parties, next of kin, as well as creditors. So that's why the public record is part of it is important. And then once part of the probate process is having the administrator of the estate officially qualified, and they are bestowed with the duties of the fiduciary duties that we talked about of properly administering the estate. And the way it works is it's all remote now for the most part, and once you've found that you're the administrator, and if a estate needs to be probated, which most do, but there are some instances that we can talk about that you can kind of avoid this whole thing. But you contact the probate clerk, you set an appointment, You send them the original will, the death certificate, and then you get hit with a ton of paperwork. You've got to file an inventory of assets. You've got to post a bond. A lot of people don't realize that an administrator has to make some sort of financial post some sort of financial collateral, which oftentimes is about 1.5 times the value of the estate, to the county, to the circuit court, as an assurance that they'll carry out their duties, their fiduciary duties as administrator of the estate,
Hmm.
properly.
Do you mean
That
1.5%? 1.5 times the value of the estate?
Yep. Yeah. So if you got $1 million estate, you got to post a $1.5 million bond. And so your bond here most times is your word. Particularly if you've been named in the will, and you're a Virginia resident, that's good enough. You just basically sign a paper saying, I hereby pledge this amount of money, and I'll owe that if something goes wrong, if I abscond off with all the assets of the estate and move to the Caribbean. However, there are instances where if the executor qualifies, but they're not a Virginia resident, or if they're a hired fiduciary, for instance, if you've named an attorney that wants to come in and have them carry that out, you have to do what's called posting surety on your bond, which means you have to go to an insurance company, essentially. Think of bail bonds, like Chico's bail bonds and Bad News Bears or whatever. So you have to basically, pay a company to post a guarantee for your bond, and that's part of the probate process. So that's involved, and then you have to file your taxes. You have to make regular accountings, and this is all supervised by someone called the Commissioner of Accounts, and they're an employee of the county, of the circuit court, who is basically the person that's responsible for supervising and approving the accounting of the estate, the inventories, and all of that kind of stuff.
Wow.
So I work with the Commissioner of Accounts, in Fairfax County. They're usually very helpful. They don't want you to get in any kind of trouble,
Right.
but they're the ones that say, okay, all the money that you've spent administering the estate on professionals, for funerals, for paying debts, all that kind of stuff. They make sure that your accounting is to a T, and that everything has been done properly.
Well, that's good. I mean, it sounds like there are people, kind of helping you navigate these waters, because they can kind of quickly get a little complicated.
I've worked on this process with now in Arlington, Alexandria, Fairfax County, and Stafford County. And I must say that the staff, the clerks, the probate clerks, the commissioners of accounts, they're all really good people that really want to help you.
That's good.
I've found them to be very informative. They'll point you in the right direction, and kind of walk you through the process, and make sure that you're meeting your deadlines and those types of things. And there's also some good resources out there. I mean, if you go to the website of the circuit court in the jurisdiction where the decedent lived, you can usually find some useful guides. There's one publication that I would recommend that's actually put out by the Virginia State Bar, and it's basically called The Guide to Administering Estates of the Commonwealth of Virginia, and it's kind of the estate administration Bible. I mean, it's a great document that the bar maintains that really kind of helps people understand, the layperson and the lawyer. To be honest with you, I refer to it all the time. So,
well, that's a great recommendation.
There are resources out there.
Good. That's a great recommendation, and it can help anybody if they find themselves in the role of having to, know that stuff. And I would imagine that the probate people, kind of knowing how complicated it is, are more than happy to help you out, because it helps them. If everything is done, the way it's supposed to be up front, it makes the administering easier down the road from there, after you get past that first one. Okay. And I think you covered going through probate and what assets are subject to probate, right?
Yeah. So this is sort of the another topic that I just wanted to touch on briefly, and that
Oh, okay.
you know, are also all estates subject to probate, and the
Mm-hmm.
answer is not necessarily. So if it's if there's no assets in the estate, for instance, they don't have to go through probate.
Mm-hmm.
But if all the assets are either, uh, and we classify different types of assets that are subject to probate and those that are not. So the assets that are not subject to probate, there's a couple of different categories. First of all, real estate. Not all real estate, but real estate that is deeded with the right of joint survivorship, and the survivor basically automatically inherits the property. So the common, obviously, instance is if a husband and a wife own a house together, one of the spouses dies, that house automatically transfers by right of joint survivorship to the surviving spouse. So in those sort of, with real estate in those processes, the real estate wouldn't be subject um, to probate. The other types of assets that aren't subject to probate are what we call transfer on death assets. And these are the assets that you own that that transfer directly to the beneficiaries by way of the beneficiary designation. So
Mm-hmm.
think about retirement accounts, your 401ks, your thrifty savings plan, those types of things. When you go and you fill out a beneficiary designation, and so that those assets pass directly to the beneficiaries,
Gotcha.
not subject to probate.
So they've just totally
Uh,
circumvented the probate
yeah,
process.
exactly.
Mm-hmm.
Life insurance is another thing. Life insurance
Mm-hmm.
proceeds usually pass directly to the beneficiaries. If you have a brokerage account, if you have a TOD bank account, a lot of these assets can be passed outside of that process.
Mm-hmm.
The last category of assets are assets that are held in trust. So what a lot of people do, and a lot of people do this specifically to avoid the probate process, is they create a revocable living trust during their lifetime. They transfer all of their assets into the trust, and therefore they're not subject to the probate process either. So the assets that are held in the trust then can be administered and passed directly to the beneficiaries without having to go through probate. So if you have a situation where you've created a trust and all of your assets are either transfer on death assets, or have right of survivorship, and everything else is titled in your trust, you don't have to go through probate. You can avoid the whole process. So
That sounds like a good way to
it's
go.
an estate planning tool that we use a lot. I've actually found myself a lot of times, though, finding people who have created a trust but failed to title all of their assets into the trust, so they had to go to probate anyway, but only to cover a very specific set
Right.
of category assets.
Which again, and I hate to sound like a broken record, but it takes you right back to set it all up with a professional so it's done the right way in the beginning, so you don't have to kind of have these unpleasant surprises along the way when you're, to your point before, already dealing with what could be a pretty sad situation. So we know what estate administration is. You explain it really well. How do you get started on setting it up?
Yeah, I mean, again, the first thing is to find the estate planning documents. Let that be your map. The second thing is, if you feel like you need professional help, call your local attorney, CPA, financial advisor. There's tons of people out there that kind of are there to help.
Mm-hmm.
Go to that guide that I mentioned, put out, by the Virginia Bar, would be my recommendation. And then pick up the phone and call the probate clerk.
Mm-hmm.
That's if probate is needed, that's where the ball gets rolling. You pick up go on the internet, search, probate in Fairfax County, and it'll take you to the circuit court, and the probate page, and you'll find a phone number for the probate clerk. Pick up the phone and call them up, and they'll point you in the right direction. They'll send you some emails. They'll send you a packet of forms and information, and then they'll help guide you through that process. So.
Terrific. Great.
The important thing is don't panic.
Yeah.
It's tough. It seems overwhelming at first.
And it is a little bit overwhelming, the process is, but it's not, it's only overwhelming because you just don't know it. It's not overwhelming to the people in the probate clerk's office who can help you, or to an attorney like yourself who that's one reason why you're there, is to help with these kind of complicated issues that, again, are only complicated because you're not familiar with them, so.
Yeah. And just realize that it takes time. I think that's one of the most surprising things to a lot of people, is that it takes it can take months, if not years, to kind of wind your way through the whole process. So people should be prepared for that.
Do you find that people our age, whose parents are becoming a little bit older? I mean, my parents have passed away years ago, and my parents did a pretty good job of setting up. They had a good will. They had an estate plan, that was obviously taken care of by their attorney, and so it was a very smooth process. But do you find that children of parents who have not set up a workable estate plan, are they more likely to be like, oh my God, I'm not gonna make my kids go through this, and I'm gonna set mine up. I'm gonna put my stuff in writing because this is just too difficult.
Yeah, absolutely, and I've faced that head on. I've certainly had clients that have contacted me and they say, I just got out of this process, and it was very difficult, and they've realized that if the estate plan had been either A, existent at all, but B, done correctly, that they could have saved so much time and heartache. And
I was going to say the heartache is really almost worse than the time. The time spent. I mean, it's the it's emotional, having to go through all that stuff, and so.
Well, and it's, without having a good estate plan set up beforehand, it can create conflict between family members. If there are multiple siblings in a family and there's no will, or if the will was not executed properly, or there are some of the provisions that are unclear. I unfortunately seen it all too many times, where there's family members that are fighting things out. And really, it's just us lawyers who unfortunately win when that happens.
That's true.
Sadly, it's I've seen a lot of estates be dwindled away over disputes between family members.
Heartbreaking, absolutely heartbreaking. Well, there's a way to avoid that, and that is to know what your options are, and to hire a professional. I mean, we talked about this already, but your last slide here is, do I need a lawyer, an accountant, or a professional administrator to help? And I guess if you're asking yourself the question if you need one or not, the call should be made to one of them, and it's kind of laying it out, right? Saying, do I need help with this?
And the level of help just depends. I mean, you might be very sophisticated. You might have a family friend that's a lawyer. You might have, a family friend that's a CPA. Or it's not saying it's not possible. But again, in my line of work, I find that there are people that wish that they would have hired, someone that's qualified, up front. And at least with my clients, I kind of leave it up to them as far as how much they want to use my assistance.
Yeah.
So, and as I said earlier, some people that just say, "Hey, please take this over for me and do
Right.
it all. I don't
Mm-hmm.
want to even deal with it. Tell me what to sign." But more often, it's all work hand in hand, with the client, and just spend a few hours, point them in the right direction, making
Mm-hmm.
sure they're staying up to date on their deadlines,
Right.
helping them identify which assets are subject to probate and aren't subject to probate,
Right.
um, and just offering that sort of general guidance that
Yeah.
really only takes up a few hours of your time, and
But it's
doesn't
peace
have to
of
be
mind. It's peace of
completely
mind too, knowing a
expensive.
professional is looking at it. Hey, Paul, we have a question from Janet Daniels. Thank you so much, Janet, for your question. She wants to know, what are the approximate price points between writing a will or establishing a trust?
Very good question. Um, just for I can't speak for other lawyers. For me, it's around $1,000.
Okay.
Depending on the complexity. I mean, there's a lot of factors that are involved, but that would be sort of a ballpark.
Mm-hmm.
Uh,
And would that be for either one of those processes?
yeah, I mean, the price difference usually is if you want to add a trust to, you do a package that includes a will, power of attorney, or a medical directive.
Mm-hmm.
And that's one sort of price point. And then if you want to add a trust, it could cost as much as $1,000 to $2,000 more. In my world, it's usually about $1,000 more. Um, you know, because it's just a lot more work. You have to, it's an extra instrument that you're setting up.
Mm-hmm.
And you're also helping people with the process of sort of guiding them through the process of funding the trust, because the
Mm-hmm.
trust, as we talked about, sort of the assets need to be titled into the trust.
Right.
So there's a bit more work involved, but
Sure.
so, if you're spending an extra $1,000 and it helps you avoid probate,
Mm-hmm.
it's well worth it.
I was gonna say you saved yourself a little bit of time and stress and heartache.
Yeah.
So, Janet, thank you so much for your question. Um, well, I think I think that's you've I think that's the end of your topic here, and I
Yeah.
just can't recommend your services enough, Paul. You really have a good way of explaining kind of complicated matters in a way that anybody can kind of understand, because it is complicated.
Thank you.
And I guess with good reason. It's usually the stakes are high. There's a lot of
Yeah.
value involved, and you want to make sure that somebody doesn't come out of the blue and say, "Hey, that was supposed to be mine," or whatever
Right.
can happen.
Right.
So, well,
Yeah.
terrific. Thank you.
Good.
Thank you again for coming on ZTV. We love to have you on
Great to
here and
be
break
here.
down these tough subjects to address. We will see you in a month, right?
Sounds good.
On March 16th. And we'll have to,
Hopefully, it'll be beautiful weather outside. We won't be getting ready for another round of slushy, icy
no,
rain.
well, I saw somewhere, do we even know what the forecast is? Did I see up to like 4 to 8 inches or something like that?
I think they've downplayed it now to an inch or two, and then
What?
turning into
You mean
a
this?
wintry
We're not going to
mix.
get snow? That's shocking.
I think we're seeing a pattern develop here.
Yeah, I know. I always say it's all that hot air in Washington blows all the snow, away from us. So,
Exactly.
yeah. All
Exactly.
right, Paulie, good to see you.
All
Thank
right.
you.
Take
Thank
care,
you
everyone.
again.
Thank you,
Yep.
Susan.
All right. Take care. All right. Okay, and that will do it for tonight's episode of ZTV Live. Thank you so much for coming in and learning about estate administration. Tune in tomorrow night, Thursday night, February 18th. It's the Virginia Amos Show, and Virginia's guest is Bill Rossello, and he is an advocate of the Bring Integrity Back to Alexandria group, and should be an interesting discussion on the citizenry and tackling civic engagement and city planning process. So please tune in for that. Virginia always is a wonderful show. That'll be tomorrow night at 7 o'clock right here on the Zebra Network on Facebook. So until then, remember to be the good news in someone's life.